From the talking stage to the doing stage, this man has been at the forefront, passionately advocating for legal education reforms in this country. Now, this gentleman is a member of parliament for the Dayi constituency. Again, he's a majority chief whip in the House of Parliament. And guess what? He also happens to be the president of the Ghana Law Society. The man, Honourable Rockson-Nelson Dafeamekpor. Honourable, thank you very much for your time with the Incoming Lawyer Media.
It's my pleasure too. And I'm impressed with what you do.
Thank you very much. Honourable, let's start from here. First of all, why does your government think that after 60 years and more, is the right time to reform legal education in this country? I mean, what exact problem are you seeking to solve?
Okay, good. Thank you very much. The legal space itself has been crying for reforms for a long time. Okay. And right from the days of the Ron's PNDC, efforts were made to introduce some reforms from what it used to be from the 60s in terms of access, improving quality, and all that. So essentially, it was about access. The space available for Ghanaians who were desirous of being trained in the law was becoming more constricted. What am I saying? When the law school was set up in the 50s, and the first graduates came up, I believe in 59, first 8 Ghanaians out of the lot that entered, graduated 59 to date, or until the 11th of May this year. We have had only one school. The population in Ghana at the time, when we attained selfhood, was about 5 million people in 57, 58. As of this year, 2026, we are estimated to be about 35 million. So within that space that you reference, we have had more than 30 or 31 million people added to the national population. So statistically speaking, more pressure has been brought to bear on the Ghana School of Law, which was in itself established by a policy, government directive, not backed by any law. So during the PNGC days, they introduced the law school introduced what they called the preliminary law course for graduates who had attained. Because of the brain drain we experienced in the 80s, a lot of lawyers left for Nigeria to go and apply their trade in Nigeria. So they introduced what they call the preliminary law course, a 2-year preliminary law course. So you had preliminary 1, preliminary 2. This was a program that mimicked the LLB courses, essentially. Particularly the compulsory ones. So when you qualified, then you join the LLB holders who were coming in from Legon.
Okay.
Because Legon was the only university that had a law faculty, I remember.
Yeah.
So the law school introduced this program by way of reform, so that graduates who are not first degree LLB holders could get opportunity to participate in the prelim program. When they qualify, then they will join the LLB holders who will then pursue the professional course at Professional 1, Professional 2. Then when you pass the final exams, you will call the bar. So we have a lot of judges today who went through that system. Some are even in the Supreme Court and the Court of Appeal. We have a lot of heads of legal departments who went through this because essentially these were public servants and civil servants who patronized this program because proximity and time of study, evening courses, weekend courses. So it suited them. And also young men who couldn't make the AA, 3As, the AB, ABB. Those days, the entry to the law faculty was very intense and extremely competitive. So if you obtain your BA in English, you could just come here. So that assisted in increasing the number of students who participated at the professional level and then got caught. Even then, it was still difficult. So in the early 2000s, so this program continued through the 90s. In the early 2000s, we saw the Kwame Nkrumah University of Science and Technology out of the blue released a statement and said they were going to establish a law faculty. The criticisms, you have to be here to listen to the criticisms. They were criticized. They were told that university originally set out to produce engineers. What business do you have training lawyers or producing LLB, running an LLB program? You should be in the preserve of the social sciences and all that. Eventually, they did it. And Director Ansasari, who was then Director of Ghana School of Law, championed it and opened it in 2003, I believe. Okay. And the faculty took off. As we speak, they are producing some of the best lawyers in this country.
That's true.
That was tech.
Yeah.
By way of reform. So now, people had options. If you wanted to read law, you could either apply to Faculty of Law, University of Ghana, or Faculty of Law, Kwame Nkrumah University of Science and Technology. Then, a boomerang. So, private universities also began to spring up. And in springing up, they also came with their faculties of law. Of course, in a democracy, people should have freedom to pursue and establish educational institutions, at all levels. So they were accredited. Then University of Cape Coast, one of our public institutions, so this amount also decided to open a faculty of law. So essentially, there's been the number of the faculties that were now producing the LLB holders ballooned. And yet, the space in the law school had become stricter and more tighter. So we're having a Coca-Cola bottle situation. Bigger base, when it gets to the neck, it's so small. So the law school introduced what they call entrance exams as a sieving process to deal with the huge numbers that were applying to gain admission. Because when I entered the law school in August 2007, we just walked in. In fact, we were called. I remember Auntie Evelyn, that was her name. That's the secretary to the registrar. Auntie Evelyn, she was all over the place looking for calling me. Because I was working. She called over 3 weeks. Wow. Before I went for my admission and registered, started. But we had come for faculty.
So it looks like you were chased.
I was chased. You understand? I was chased to come and read law, to come and pursue my professional program.
Yeah.
It's no longer the case today. In fact, somebody is looking for the fact that they should even strike off your name and said, yes, who has time for you there? So they introduced the exams and introduced interview. We were not interviewed. Because the list from the faculty was good enough. The pass list that came from the faculty. That was the admission list. Once you qualify from the faculty to LLB, that was your admission to the professional law. So when they introduced the exams, people were passing the exams, very difficult exams. Mind you, no exams in law is cheap. At any level, any form of examination at all in law is tough. People pass these very difficult exams. Then they go to the interview stage. Then you see a panel member asked a candidate, do you have a lawyer in your family? The person said no. That was your end. Wow. These things happen in this country. Wow. People were denying access to studying, to becoming a lawyer because they didn't have a lawyer in their family. Wow. It happened. It got to a stage, student candidates who had applied to even write the entrance exams were asked to sign away their fundamental constitutional right of seeking a review of a decision. Some forms were given to them to sign away their as a waiver. So that if you were told that you had failed an entrance exam, you couldn't even ask for your marks to be retabulated, reviewed, or remarked. All those things have happened in this country. Eventually, matters came to a head in 2017, 2018, where some students, about 1,200 wrote the exams, and they said only 120 or so had passed. 12%. Wow. It was huge. So it woke everybody's conscience. Everybody woke up to the reality. The students who felt aggrieved, they petitioned Parliament. The petition law school, nobody was listening to the petition Parliament. I was then a young man and I had come to Parliament fresh. But I was on the Constitutional Legal Committee. When they came, we listened to the issues. Things were horrible. So we took a decision. When we reported to the Parliament eventually directed that the interview be scrapped. And they said they couldn't do it because it was part of the LI. So we said they should bring the LI. So they brought the LI. And then we struck off the interview. And they went to implement it. The following year, it was worse. Worse in the sense that because they took out the interview, they were now filling the students. And because the exam now became the only sieving process, isn't it? So they were now deliberately failing the students. When students felt aggrieved to seek for a review, there was no review process. I did a court of law. When a party is aggrieved by the decision of a court of law, the law permits you constitutional right of appeal exists. Just were not happen. And then we got to know that even some persons are admitted to the law school who didn't write the exams at all.
Wow, they didn't write the entrance exam?
Yes, backdoor admissions were happening. These are contained in official reports commissioned by the General Legal Council itself. Scandal. So we said no way. So I became the advocate. Eventually, that storm also blew over. Then, if you recall, the election year, 2020, another huge number wrote the entrance exams. And they filled a particular number, 499.
The 499.
So they came to me. I'd made my name in this way. They came to me. So we said, no, that it won't happen. They demanded. So I advised that they should sue. Once they sued, I was pursuing the advocacy on the parliamentary floor, making statements. I got MPs to understand the issues. They told these 499 students that they had failed, and there was no way they were going to review their marks and all. The students came here.
Yeah.
They went on a demonstration. They were beaten.
Yeah. I remember that.
They were. So let's tell you what. When we interrogated the matter, the scandal was bigger than what we had all thought of. So quietly, they agreed that they will admit the 499.
Yeah.
Nearly 500 students that you claim had failed, that they were beyond redemption.
Yeah.
When we threatened to expose the issues, they agreed that too, and they admitted them.
Yeah.
Today, nearly all of them are lawyers. They see me, when they see me, they stop their cars.
Yeah.
They get down, they hug me.
Yeah.
Because they tell me, but for the things I did that time, they wouldn't have been admitted and they wouldn't have been lawyers. Some are running their own chambers now.
Oh.
So when the elections were over and we returned to Parliament in 2021, Susu and I then joined me at the bar for the advocacy. So when he got the opportunity to enter Parliament, he and I, we filed a private members bill.
Okay.
For these reforms. So these reforms.
So that is a genesis.
Yes.
Okay.
We filed a private members bill, but because of the nature of what we were looking for, he needed to involve the stakeholders. Who are the stakeholders? The judiciary, naturally. The law school itself, naturally. The General Legal Council, naturally. The Attorney General. They were not interested. They were interested in the status quo because it was benefiting or serving some interest.
Okay.
So some even if I because these are matters of fact. When the media engaged us and engaged Senior Samuel Kujeto, he called us were small boys. That the kind of reforms we're asking for will happen over his dead body.
Wow.
And that we should tread cautiously. And that he even threatened us, reporting us the General Legal Council. Lawyers, a senior lawyer threatening to report to me. Me doing advocacy as a member, elected representative of my people in Sometime. So I told him that first of all, I wasn't engaging him as a lawyer. I'm engaging him on a matter of public advocacy, and in my standing, my locus in that matter was as an elected representative of the people of Sometime and as a bona fide member of Parliament. So he was blowing hot air, was an empty threat. And the reform may not happen today, Senior, I can assure you. But at the opportune time, it will happen. Let's mark these words. In my village, they will tell you, go and mark it when rain falls, water won't touch. Here we are. So when we began preparing for the 2024 elections, because of the failure of the stakeholders to take up our private members to support us to push it through, we made it a point to convince our party that it was a major matter for the thousands and thousands and thousands of law students, not law students, but graduates with LLB, who had practically been denied the opportunity to become lawyers, to pursue, to enter the law school, become lawyers. So let's make it as part of our promises under the legal reforms, and do it for them. You see, we have been struggling in that space as a party, but if we do this, I can assure them our fortunes will change. In the meeting, everybody was looking at it. So they took it on board. These things, it goes several layers before final approval comes. Eventually, when the senior lawyers, when they went to meet and they were informed that these were my very deep concerns, they thought that, why not? It won't hurt anybody. So it stayed in the manifesto. We campaigned with it. And so as soon as we came, I said, hey, you have to do this. So, and luckily, Dr. Ini himself also was part of the advocacy at the time. He bought into our idea for reforms. And he, having had the opportunity to now become a substantive attorney general, we encouraged him. So eventually the bill came with all the issues that the people voted. But we are here, it's been passed and assented to. And let me clear this today. It's an absolute falsity that the Ghana Bar Association claims that they were not consulted.
Okay.
They were consulted. Okay. They participated in the stakeholder engagements. Okay. They actually brought a memo.
Okay.
They sent the committee a memo containing what they considered to be their idea of the reforms. Okay. And we consider some of them. Okay. And these things, it's not every proposal that you bring that will be accepted. Indeed, the bill itself, the original bill, contained a lot of other renditions, but they all got amended and got straightened until we got the final product as you see it, which has matured into what we call Act 1170/2026. Yes.
Thank you very much. I think that that has been a very great historical antecedent as to how we got here. But let's look at this again. Honourable Dr. Matthew Poku-Prempeh, who had been a member of this house for a number of years, at the time, before it became an act, he actually had this to say. He referred to the bill at the time as a bad-crafted bill. And that's not all. The former Attorney General, Honourable Godfrey Dayi, also had this to say. He said that this bill is ill thought through and can only lead the nation down a very dangerous trackway. Honourable, upon hindsight and being objective, and let's put some politics aside, would you want to agree with them to some extent?
To which extent?
To the extent that recently...
No. I understand the question. What is exactly is Matthew Poku-Prempeh talking about? First of all, he's not a lawyer. He's a medical doctor. He's a dentist, trained dentist. Which part of the bill is supposedly badly crafted? Which part? Is it the English? Or we use English to draft bills? Which one? Has it got a problem with any of the syntax? That's the internal structure of sentence or what? You see, the NPP in government refused to accept the reforms, even a modicum of it. They were not interested. They constitute, because a lot of their seniors constitute themselves into that school of thought that said we must never open up legal education to other Ghanaians. Okay. It must be jealously guarded for some of them, because you see, and I say this without hesitation, because the report exists. When you check the reports of the ad hoc committee established by the General Legal Council, of which the former Attorney General was a member of the General Legal Council, and the former bar president was a member of the ad hoc committee that inquired into the scandal. The people who were admitted to the law school without writing the exams, some were children of senior people in the NDP. Okay. Do you understand my point? So, even at that level, they were playing politics with the school's admission. Okay. And they were creating very feeble opportunities for their wards and family members, to the detriment of fair play. And you see, this reform has caused all those things to be evaporated. they no longer will serve their purpose. So they are agreed. So it's a tragedy that we have, with all due respect to him, that a member, somebody who has served in parliament for about four terms, been a minister of education.
Yeah.
And mind you, legal training is part of education. Educating the mind of the people. We'll say this about this reform. This is a reform that is opening access to legal education everywhere, where you have an accredited faculty of law. So that when the faculty of law of University of Development Studies is accredited, for instance, I don't have to travel from Tamale to even to Kumasi or Accra in order to become a lawyer. That is where the nation must be headed. That we must develop as a people to the extent that opportunities must be fairly distributed wherever you are, so that you can participate. Do you know how many law schools we have in England? Are you aware that the physical side, the geographical size of England is akin to the size of Ghana? You know that?
Yeah.
You know, England is an island. The United Kingdom is an island.
Yeah.
It's the landmass. It's about the landmass of Ghana. Go and check the number of law schools they have vis-a-vis their population.
Yeah.
And yet they send their children to England to go and attend a lot of the law schools and faculties and law schools. And they are happy that they are called to the English bar. Because the opportunities abound everywhere. Because you see, an educated mind, a legally informed mind, is better than the other. So if you have a greater number of people who are going through legal training, it is the nation that gets better. In terms of thinking, approach, everything. The nation is better off. People think that becoming a lawyer means you must wear gown and bib and wig and go and no. That is their convoluted sense of being a lawyer. We have moved far away from that. People want to be a lawyer for just the sake of it.
Yeah.
I was in class with medical doctors. They are still practicing their medicine. They are my classmates. So we are 16 years at the bar. Wow. When they are confronted with issues in their management meetings, they don't look for lawyers anymore.
Yeah.
They follow them for legal opinion because they are keep up.
Yeah.
That's what must happen. You must have engineers. I was in class with engineers, civil engineers, building technologists, who have also become lawyers. They are not supposed to be doing my lord, my lord.
Yeah.
No, that's not how we should approach things. One of the problems we are saying discipline is because people cannot even interpret simple administrative guidelines and apply it. Our district, if you follow public account hearings in parliament and you follow auditor general's way, the leakages and the malfeasance occur greatly within our assembly, district assembly structures. We don't have lawyers serving there. If you have lawyers in each district assembly, then I believe that some of these malfeasance or non-compliance issues, you have 30 days with able to do this, they don't do it. When you as a spending officer, when you incur certain expenditures, you must account for it. They don't do it. Lawyers could have been guiding that within the meaning of the PFM Act, Act 921, 2016, or its regulations, Regulation 7374, or other relevant laws, or within the Local Governance Act, Act 936, I believe, 2016. Lawyers will be guiding that. But we don't have lawyers even serving on assemblies. If you watch, the number of traditional councils that we have set up, even between 2017 and 2024, by the NPP ballooned. And you know, as somebody in the law, you know the functions of the traditional councils.
Okay.
Because they have judicial committees. And the judicial committees are supposed to be determining chieftaincy disputes. You need lawyers to assist them at that level. Because when a chieftaincy dispute erupts, it ends up in the Supreme Court. If they get it twisted from the beginning, it may take the Supreme Court to straighten it. But if you have lawyers even operating at that level, it helps. It reduces the dispute. And even how long it takes them to determine. They don't have lawyers. And here we have people who have served in public service in the highest places say that we may be producing too many lawyers. However, a lawyer is an economic resource to any nation. Why? Because the lawyer does not require employment. The lawyer employs himself and employs others. When he employs others, he will pay them wages. When he pays them wages, they will pay taxes. He will pay taxes for setting up his law firm and operating it. Again, people don't avert their minds to these implications of commercial and economic proportions. So, the former Attorney General and the former Minister of Education merely played politics. But again, they got drowned by the thousands and thousands and thousands who bought into this idea. And which is being influenced.
In fact, I must confirm that almost all the LLB students are excited about this bill. But again, still on this issue, just recently, a group calling itself National Association of Law Students or National Alliance of Law Students also has something to say, more like a critique of the way we want to go with the legal education reform. They were of the view that the introduction of the pre-bar course is burdensome, it is legally questionable, and it is insensitive to LLB students. What would you have to say about something like that?
Now, those are some strong words that they put together. If I find anything, I'm sure you must have followed me in my public. If I find anything unlawful, I don't talk. I just go to court. I don't talk and threaten and no. I just sue. And so the courts determine. If they think that the introduction or the formulation to deal with the backlog of costs of the LLB holders who didn't get an opportunity to take these courses that we are offloading from the professional level to the academic level. If they feel that that model of implementation is unlawful, they should test the law. It's not about press conference. Press conference won't solve this problem. If you think it's unlawful, test the law. 2. You see, because they have never believed in the reforms, so all the new things that the reform is giving birth to, they are against it. How can anybody say that the reform naturally is going to occur in such a way that I have an LLB, fully accredited LLB program, well qualified, I've been admitted to the professional level, yet I am deficient in some very key courses. So at what time am I supposed to take those? On a part-time basis, in another school, or in the same school on part-time basis? So that is why this is an innovation to say that, okay, now as part of the implementation, let us introduce this interim model, because it is to clear the backlog. Because the curriculum reform is going to incorporate these courses. And I champion it.
Okay.
I said company law,
Okay.
interpretation, labor law, evidence, ADR, family law. These are essentially academic courses.
One question.
Taxation.
One question that has been on the minds of people or those LLB students is that you know a lot of LLB students have already offered company law, and some of them have offered ADR.
Yes.
When they go back for the pre-bac conference, pre-bac course, are they going to study the company law again?
No. You must listen to. You must pay attention to the bulletins. Maximum 6 courses.
Yeah.
Minimum 4.
Okay.
Pay attention to the bullet.
Okay.
So, in cases where an LLB holder already has taken 3 credit hours in company law, there's no need to repeat. But when they did the computation, in some schools where the company law was not taught, as part of your LLB curriculum, you take it.
Sure.
But some schools introduce it as part of the LLB curriculum, so they will be exempted from those.
Okay.
But there are, if you take all the courses, at least there are some 4 that cuts across that you are likely to take minimum.
Okay.
And where you don't have the others, then your courses may go up to say 6. I don't think it will even go beyond 6.
Okay.
So it's between 6 and 4, depending on which school you attended, or which LLB you possess, and from which school. So that's where we are.
Okay. It was mentioned that as part of this pre-bac program, some attestation.
But let me also say this: I thought that even the name pre-bar, it's a misnomer. Okay. Because this is not strictly pre-bar.
Okay.
The pre-bar is actually will occur after the professional training.
Okay.
That's where you be entering a pre-bar.
Okay.
So I think it should be a pre-professional doctrine. A professional training. So that's
okay. But again, on that pre-bac, it was mentioned that some attestation will be given to the student, certifying that you have actually completed those courses, and that would allow you to apply for the law practice training yourself.
You see, the law practice training is a professional training stage for 1 year, very intensive. But so they are going to make these courses like a prerequisite. You will need to have them as part of your transcript for purposes of admission. So I agree that it will not be an attestation; it will be a supplementary transcript.
Okay. So that means exams will be written. And
yes, but law. You see, this law students don't fear exams. Let me make this point: law students anywhere. They don't fear exams. Okay. The problem with the exams that we have all complained about is the entrance exams that has been, technically speaking, was not serving the purpose. Okay. It had rather become a dangerous tool in destroying the life of young Ghanaians with great potential in illegal work. Do you understand? And that's all we have eradicated. But a lot of the opponents to this reform will say, entrance exam is still there. But who says there will not be any entrance exam? If you read section 45 of the law, section 45(1), we deliberately inserted entrance exam so that when you are entering the faculty, when I was entering the faculty, I wrote entrance exam.
Absolutely.
And so that's not the point. The point is that there must be uniformity in doing that. But you don't use an entrance exam to deprive people who have even qualified from having access. And they don't want to appreciate those. So they go on harping about entrance exams, There will be exams at any level. Internal assessment, IAs. It's always an exam. So law students don't fear exams. What this reform has done is to eliminate that obnoxious entrance exams that was existing under the old law school regime.
Yeah.
That is gone. IAC no longer has the power to do that to thousands of Ghanaians. No, it's gone. But there are other forms of exams by way of your training. When you are going through the training, you will be writing exams. So yeah, that's in any case, that is what we call assessment.
Sure.
You can write exams. Some you may take written exams, you may take oral exams, but it's an exam. You must be examined for your suitability to be determined. Yeah.
Sure. Honourable, the law practice training, what thinking went into making that just 1 year instead of the 2 years that it has always been?
Because we, as part of the engagements and deliberations, and I made a point that we have overburdened the students at the professional level.
Okay.
Look, you leave home, you start lessons at 6 a.m. and you don't on a regular day, you don't end your lessons until after 6 p.m.
Yeah.
How is the student going to rest and study and be ready for the next day?
Yeah.
So let us look at the spectrum of courses available. Company law, academic program. Every company law is about this academic work. Okay. Interpretation of deed and statutes, academic. For me, evidence, academic. Taxation, academic. Family law, academic. The family law you practice is not a family law that's taught in the law school. No.
Okay.
You understand?
Okay.
Then, even for me, advocacy. So you see the advocacy exists both at the LLB as part of the curriculum reforms.
Okay.
We are indicating that advocacy will start right from the LLB.
Okay.
And then you continue because legal work is essentially about advocacy. So it's good that it runs through. Then at the professional level, we'll leave the procedure practice oriented courses.
Okay.
Civil procedure, grandmaster. Criminal procedure, grandmaster. Advocacy, you will stay. Conveyancing, thank you. Drafting. Even drafting, we're also introducing drafting at the LLB level. So that you can acquire the very difficult skills of legislative drafting as well as drafting of legal instruments and processes. You see, you don't have to get to the professional level before you master how to draft pleadings, how to plead. Save as hereafter expressly admitted. I deny every material averment of facts as contained in the plaintiff's statement of claim, as though same were denied in extenso and the seriatim. General travels. It's something you must master in level 100. Because in practice, when you are sued and your client comes to you that he's been sued, your first pleading, paragraph 1, is your general travels. Or you take it to the last paragraph and then you plead it. So there are things that will live with you forever as a practitioner. So drafting is a skill you must acquire early. All right. So these are the thoughts that went into it. That is why there's a general agreement with the proposal that we put forward. The academically oriented programs all should be shipped downwards and make the LLB program more dense because they are spending more time there. Make it more dense and infuse it with some practice-oriented programs. So advocacy, internship, drafting, all those. So that when they get to the professional, they are focusing on the procedure courses. 1 year you are done, you are issued with your certificate, then you are submitted, or your eligibility is now established for you to write the national bar exams.
Well, I think that I would largely agree with you with the explanation you gave to the 1 year now. And that has been the reason why the pre-bar is very necessary.
Yes, because there are courses that were hitherto until now were part of the programs we're taking. So you did professional 1, professional 2.
Yeah.
You know, semester 1, semester 2.
Yeah. Very well. Let's look at again the one of the reasons for this reform. And I believe that when you were actually advocating for the reform, one of the things you mentioned that you kept mentioning was access. I mean, to increase access. I would want to look at access in another way, whereby I would want to look at it geographically. For instance, if you look at section 22 of the Act 1170, it stated the various procedures or the various qualification requirements or the standards and the requirements.
The checklist.
Yes, for the various faculties to be accredited. Would you want to look at it in a way that, for instance, let's say UDS, right, which is up north, assuming without admitting that they are unable to meet the standard for accreditation, would government want to come in and cushion them to be accredited just so that they can also be able to serve persons up north? They can have access to legal education up north.
Now, it will be a dangerous thing for government to do, because you see, in that space, the public universities are also competing with the private universities. It's a fair play. Mind you, this legislation is a leveler of all. It's supposed to provide like even playing field for all participants. So government cannot go out of its way to focus on enhancing the chances of another. But it will be in the interest of government to encourage that. So government it is a public school, the public university, with the governing board. So government can direct the board that because of this very fundamental new policy introduced by government, focus all resources in enhancing the eligibility abilities of the law school to be accredited. The government can do. They've got the vice chancellor, the chairman of the governing board. Government has appointees who serve on the board. So answering your question in the converse, government will rather find a way to influence the focus or resource allocation decisions of the board or the governing council to go to enhancing the chances of the law school meeting the accreditation standards, so that they can receive their provisional license and take off. Because in all this instrument, this legislation is a revenue making legislation. The schools are going to charge fees, and the fees will come to government. The private ones will remain with private ones. So it's such a major legislation which implementation must not be frustrated at all. You understand? Yeah.
So in implementing this on pilot basis, are you looking at limiting the accreditation to a specific number of universities?
It's another propaganda. I see where you are going. It's another propaganda that has been put out there, very terribly done. You see, law is a tool for social engineering. We have introduced this legislation to deal with problems such as the one you referenced. Do you understand? So how can that new legislation now be encouraging such a practice? So it won't happen. There will not be any pilot. It's an opportunity for all. That is why all the existing G-Tech accredited law faculties have been given the opportunity to apply. There's no facing. That is why within the law, and in getting here, the deans of these faculties or law schools, as they want to be called, have But in fact, a lot of the portions of this legislation, they were crafted and introduced by the deans.
Okay.
They brought the amendments and said that they are operating within the space. This is how they want the things done. And we listened to them and adopted them. So a lot of the provisions you see in the law came from the operators of the law schools. That this is how we think that it can be done. And so they brought it and we adopted it as part of the law. So the faculties, they know the demands, the prerequisites. And I know that some schools are recruiting PhD holders to satisfy the staffing requirements that a lecturer must have a minimum of a PhD in law to be able to qualify to teach under this new program. So I know a lot of them are easily recruiting young people with PhDs to meet the criteria. And they are sending in their application checklist, application package. It's a whole package that you the form and the requirements it's quite a lot. And they are applying. So it's a play all. If you bring your application and you meet the minimum standards, then you are qualified for the provisional license. Then the provisional license, within 2 years, you must put in application for the substantive license. So these are the allegation that some schools have already been selected by who? The council has not been established. So by and yet you have lawyers saying these things. Emphatically. Just to give a dog a bad name and hang it. So no school, whether private or public, will be deprived of the opportunity of applying ab initio. Put in your application for accreditation. If you meet the initial checklist for accreditation, you will be accredited professionally.
Great. So that would also mean that there will not be a cap on the number of students each of these universities are allowed to admit.
No. It's going to be from each according to his ability and to each according to his means. If you have big space, naturally, well, don't let me do this. Otherwise, I'm going to compare two schools.
You can use A and B.
The school A may have been doing this for the past 50, 60 years. And you have been you are even a private school, you've been doing this for the past 10 years. Actually, you cannot compare yourself to the abilities of school A to admit more. You can't. But what is important is that you are also granted space to operate within that space. Or you are granted the provisional license to operate within that space. And you admit students according to your ability. It's part of the checklist that if you over-admit, and we see that it has a toll on your facilities, you will be sanctioned. It's not because of school fees, so you want to over-admit. No. So the regulation is going to set out all this. We don't want overcrowding. That is why all the faculties will be they are supposed to be accredited. So if a student apply here, he doesn't get a chance because of space, he should be able to apply to another school.
Okay, Honourable, you said a lot about, we are very much aware of the issues around the entrance exam being the reason why this reform is here. Then again, there comes the bar exams. So the concern has always been that the entrance exam was denying a lot of people the opportunity to enter Makola and subsequently become lawyers. With this reform, are you assuring us that the bar exam will not become a miniature of entrance exam that will be used to deny people the opportunity to become lawyers? And I'm talking about a situation where there could be a regulation that every year there should be a cap on the number of lawyers that are produced. We are still on the numbers.
Why? Which law? Which law will prevent that? And again, again, this sort of thinking have come from the same quarter. So how can anybody reasoning properly compare an entrance exam to an exit exam? An entrance exam was denying people from being trained as lawyers. And it was organized in increasingly the organization are run into some fraudulent processes. I means no words. To the extent that lawyers have now found it a commercial venture to be running extra classes and charging people LLB holders who patronize these classes exorbitant fees. Someone told me that he paid 5,000 for a supposed 2 months, 6 weeks or so, or 7 weeks of class time. 5,000. And he said there were over 400 in class. And we have lawyers boasting that if you attend my class, the pass rate for the entrance is like 90%. And because we mark the entrance, we mark the entrance exam. Lawyers doing this. And these are the group of lawyers who are against the reform because I've taken bread from their mouth. So it's about bread and butter matter. All the arguments they were making against the reform is about their bread and butter. That is why even after assent, they were insisting that implementation cannot be implemented. So as for the entrance exam this year, it must happen. They want to have a last bite. It won't happen. In fact, some took money. So I told the student to go to them and collect their money. Because the entrance exam, as we know it, organized by IEC, we abrogated it with Section 93, transitional provisions. We that with it. So it's a process that ought not to be compared because the national bar exams is the final litmus test for the exams you're written from level 100, the mid semesters, the end of semester, the IEAs and all, the moot court, all. The bar is the final sieving process. So you are already baked. The bar is to mint you. If you are not minted, you prepare, you take it again. You are not thinking of any entrance exams which would deprive you. All right? Yeah. It's not deprivation. This one is a final assessment litmus test. That must turn enough telling blue or green.
And again, if you don't pass the pre-bar, you can't also enter the law practice training.
Yes, because the pre-bar is the structure is such a way that it contains some number of courses. They are like core. They core and elective. So they are like core programs that you want to take at recently at the professional level. We are offloading them as academic oriented programs into the LLB. At the time you were studying for your LLB, they were not available, so to speak. But now they are available. But the structure is such that you cannot return to the LLB to do this. So it's a modular program, so to speak, to ensure that you took these courses and passed them, and then you are issued with a supplementary transcript. Because they will come with grades, for which will now make you eligible to read for study for the professional training. Yes.
Honourable, so currently the backlog of LLB students is between 5,000 to 8,000, and this year, or let's say next year, we are going to add thousands. Are you saying that if the accredited universities are able to totally, let's say, train about 6,000 lawyers, a year will come that would have 6,000 lawyers called to the bar in 1 year?
What is wrong with that?
What is wrong with that was what the former Chief Justice of Akufo told us. She said that those of you are busy advocating free scale mass admission into the professional law course and mass production of lawyers, you must be very careful what you wish for. Just like you cannot mass train doctors and surgeons, Ghanaians must not have mass produced lawyers imposed on them. So I ask you, what is the golden lining that you have found in mass production of lawyers?
You see, when it suits them, they use socialist terms. Mass production. Who is producing lawyers and mass? Who? Which part of this legislation is suggesting that lawyers will be produced and mass? That is unchecked, unrefined.
Yeah.
In fact, the new reform is going to make it more difficult to become a lawyer.
Okay.
And that when you become a lawyer, you'll be better. You'll be better when you are baked, when you are freshly minted. Your abilities will be far better than we are producing them now.
Okay.
Their problem is about numbers. But you see, it's the same arguments they made when Tech again decided to introduce medical school.
Yeah.
You know, Tech didn't have a medical college. They only had engineering. The only University of Ghana had it. The University of Ghana Medical School. When Tech wanted to, they said, there will be mass production of doctors. Same arguments. I was here. I was in this country. When UDS, when President Rawlings established UDS and UDS blossomed, and they decided to introduce medicals, even that one, they were doing it under the tutelage of University of Ghana. Come and hear the arguments. There will be a mass production of doctors. There will be too many doctors. Today, we even have private medical schools like Family Health. Do we have too many doctors in Ghana? University of Cape Coast has a medical school. Kwame Nkrumah University of Science and Technology has a medical school. University of Ghana has a medical school. There are private medical schools. UDS has a medical school. So now the medical schools, both public and private in this country, will be about 10. Aren't we crying for more doctors? Still, aren't we saying that we don't have enough doctors? So when you compare the existing facts, the facts as they exist on the ground, it totally defeats this logic that they've tried to edge on us. Today we are looking for lawyers with PhDs to teach at the law faculties. We are not getting them. Are you not surprised?
I am. I should be.
That with these reforms, the requirement is that every faculty, the minimum qualification, must be a PhD in law. So all my colleagues who have LLMs, their faculties are sponsoring them quickly to do a PhD, so that they can respond to the demands of this. And yet, we have people who have had opportunity to benefit from the system claim that we'll be producing too many lawyers. But let me leave those matters aside and insist that this new legislation, this new reform, has rather introduced a more stricter, a more heightened standards of training in the law than before.
So the assurance in there is that the quality will not be compromised.
Please, the quality levels have rather been heightened. And I've told you that it will be more difficult to go through this system to be baked as a lawyer than we do have now. And you just have to pay attention to the requirements even at the LLB levels to appreciate what I'm saying. At the LLB level, so we are going to teach the law students legal skills such as client handling, law firm management, advocacy, drafting, academic publications, It used not to exist as part of your assessment.
Yeah.
No. If we are gifted, you could author a couple of academic articles as a pastime activity.
Yeah.
It was not a requirement for which you were graded. No. Then now we say you have to, as part of your assessment, you must produce at least 2 academic publications of some quality, publishable in reported journals. That is where we are now. And yet people say we are watering down standards. It's sad.
Yeah.
Because they have refused to read the law. And with all due respect to CJ retired Sofa Akufu, she has been against this reform. So look, the day she heard that I'd filed private members bill, she would be sick. And I remember this speech where she I think it's 2022 or so, or 21. I recall. It was one of those mini bar or bar conferences, and I listened to her and I smiled. There's nothing like mass production of lawyers. England is not mass producing lawyers. Is it Nigeria?
Yeah.
Nigeria is not mass producing lawyers.
Yeah. Interestingly, the England, I mean, over there, the lawyer to citizen ratio is about 1 lawyer to 426 citizens. In America, it is 1 lawyer to 256, and the international standard is supposed to be 1 lawyer to 250 citizens. With this reform, yes, in Ghana, it's about 1 lawyer to 2,000 citizens. And I know with this reform, obviously, we are going to close the gap, and that is where quality, as you have assured us.
And I wish that you'll be pushing this ratio and percentages for people to appreciate.
Yeah, yeah.
So you see, there will never be too many lawyers. In the same way, the University of Ghana produces engineers. Science and technology, they produce engineers. TACWA, they produce engineers. Now, University of Cape Coast is producing engineers. We have the private universities, they are producing engineers. And yet, we don't have too many engineers. We are still looking for engineers to build our roads, to build our buildings. We suffer excessive flooding in the rains. We need the hydraulic engineers. We need civil engineers to build our civil infrastructure. Do we have too many of them? So I believe that should
answer the question, absolutely. But still about the pre-bar course or program, how long do we intend to run this outside the LLB schools before finally it gets incorporated into the LLB, whereby when you are ready to enter for the law practice training, you don't have to do this again?
Okay, it's a model. Now the incorporation is being done now. So all the LLB, so the LLBs will have a reform curriculum.
Okay.
So this model or this modular is to take care of the backlog. So once the backlog is cleared, that's the end.
Good.
That's the end.
Good. Honourable, this legal reforms that we are seeing, what do you envisage to be the effect on the future of our Ghana legal system?
I envisage that there will be better provision of legal services because the system is crafted to focus more on quality, high standards, ethical behavior, and all. And I believe that it is the nation that will be the ultimate beneficiary. Then also, in terms of professional socialization at the bar. Like I have set up the Ghana Law Society with membership in excess of 2,000 professional lawyers, with a student membership in excess of 8,000 as we speak. Because the problem with the Ghana Bar Association is that, and this was where I saw it, when the law students were having problems at the Ghana School of Law entry, even those who were there, they had issues. They would write exams, there were issues. They couldn't even, when they asked for remarking, it became war. The Ghana Bar was never speaking for the students because they are not set up to fight for the interest of law students. They are set up to fight for the interest of professional lawyers and judges. When judges have their own association of judges and magistrates and judges, but they sparingly speak for judges. It's always the bar that rather speaks for judges. And you hear them occasionally, they speak for the interests of lawyers. Mostly they'll double into national politics. Meanwhile, you are an association of professional lawyers. Lawyers have concerns. Courtrooms leave much to be desired. Facilities are determined. They won't address them. They won't call for consensus building on those matters. No. It lost its focus. So when we were setting up, we decided that we'll focus on the interest of our members at the bar in practice. The things we must pursue to make practice better for our members, like introducing insurance and welfare packages for our members.
That's the Ghana Law Society.
Ghana Law Society. And as a marked departure from how the Ghana Bar Association GB is set up, we will have student membership. So that when you are a student, you are a member, we will give you what we call student membership. When you graduate and you become a full-blown professional, you just transition from student membership to professional membership.
That sounds good.
So that when law students are facing difficulties, the Ghana Law Society will have the mandate to speak for their interest and defend them, because they are our members who are students. So their welfare is of paramount interest to us. So, and people are falling in love with this.
I'm falling in love with it already.
You understand?
Said,
So, because you cannot do. In fact, if you take the international bar association, the IBA, they have student membership. So when you want to attend an IBA conference, you have options. Professional membership. Are you a professional member belonging to a member association, a national member association, or you are a student? And when you are a student, your package is different. That's how you must do things. They have a youth week. Why do you think that they create a forum for young lawyers? Because of exactly that. You are young at the bar. You have peculiar interests. Me, when I became the interim president of the Young Lawyers Association within the Ghana Bar, we were resisted. Samson Ayinene was my vice. We were encouraged by Lady Amegache when he was president. Best party. So he returned, said, no, we should do it. So he got me Samson around 2010. That was when we were pursuing the Justice for All program. To identify, I became president, Samson vice. There were hawks who thought that we posed the threat to their executive role because our numbers were huge. So they thought that if they gave us opportunity to be incorporated into the mainstream bar association, we overwhelmed them. Because when it comes to voting, the young lawyers were in our thousands. At that time, we were many. So if you put the matters to vote, our views will dominate. So they prevented it from happening until I overgrew the association and left and came to Parliament after 7 years. Because by our constitution, you can only be you can remain a member of the Young Lawyers Forum up to 7 years. And then you have to exit. You understand? Eventually, a couple of years ago, they adopted it. So now you have a young lawyers forum wing, and they are women's wing too. So we have all that. Plus the students, student membership drive, and we have chapters. In all the accredited faculties. So University of Ghana chapter, Wisconsin University chapter, Central University chapter, UPSA chapter, UCC chapter, and we have we've established we have an executive in all this, and they are working. So the student membership is in excess of 6,000.
Impressive.
And the professional, the lawyers, we are in excess of 2,000, and we are growing.
Wow.
So believe you me, in the next couple of years, we'll be formidable. So, Ghana Law Society will be formidable.
Honourable, before we go, there is something the Incoming Lawyer Media is particularly interested in, and that is the building of the Law Village. I mean, after the soft cut in May 2021, the project got abandoned at the foundation stage. Now that we are reforming legal education in this manner, whereby a facility like this will be needed to actually be serving more like a law headquarters, would your government want to consider taking up the project and building it? And
the Law Village was Georgina Wu's baby. If I recall. She, in 2010, we worked closely together, so I knew some of these things intimately. So that was a baby. So it was also part of her decision as part of the reforms, actually. So her intention was to actually move Makola from where it is to the Law Village. That's why the whole enclave was called the Law Village. Because of space. And maybe reduce the current structures at Makola to serve some judicial purpose. But the intention was to build the Law Village and move the law school. But I can understand that, it's about leadership. And she pursued these grand projects as the Chief Justice, policy drive and all. So when leadership changed, and you don't have the same motivational levels from the succeeding CJs, it affected the project naturally. If she had remained in office for the next 5 years or so, I can vouch for the fact that it would have been completed because of the drive that she had for the project. But as soon as her time was up, she would turn 70 and had to constitutionally had to leave. The successor maybe didn't buy into the idea, so it got gradually abandoned. The successor after that successor after that successor. So the Law Village bears the soul of CJ Wood. And that being like a personal project, that should focus leadership, resources. We need another CJ to maybe
to look at it,
to revive it. Yes, it's not a government. It's not a government. It's something that the judiciary was pursuing. Because of the close relationship it has with legal education. So they were, and it was to the Law Village, as the name suggests, was to be a one-stop shop. Enclave where you have the school, you have moot courts. You have all sorts of facilities,
canteen,
library, canteen,
bookshops, and all.
Yes, even I think even supposed to be guest rooms. Yes, to house, especially when they get visiting judges on sabbatical and then academic terms in the law. When they visit, it could be an enclave where accommodation was ready. But so, sitting where I sit, I believe that I can make a statement regarding it and see how we can revive it.
The Incoming Lawyer Media will be grateful for that statement you made to push for this. Honourable, your last words before we go.
Yes, we want to assure all prospective law students that the reform is the best thing that has happened to them. And also to assure all those who are already going through the process that the reform has rather come to streamline and take away the perennial pain that they went through. Even when you pass the exam, they tell you haven't passed. And when you want to cross-check to ascertain the facts, you were denied. Those horrors are no more. The Egyptians you see today, you will see them no more. So we should all assist in the implementation process. We are still rolling out the measures.
Yeah.
Law is a tool for social engineering. We are not saying that this is the end of the reforms, but with reforms will come further reforms, and then we'll get better as a country. So, as for the naysayers and those who are insisting on the Mokola entrance exams, ex nihilo nihilo face. You can't put something on that and expect it to stand.
Absolutely.
No entrance exam will stand now because IEC is the power of IEC to do that has been taken away by Parliament, and so there are no locus to organize any such entrance exam. So let it be settled today that the entrance exams entrance exam in the form and nature and character that you need with before you enter law school. It's no more. Yes.
In other words,
in fact, law school itself, under section 77 and 78, we have had to re-establish it.
Yeah.
You know, when I discovered that law school was not set up by an act of parliament, it was by government policy.
Okay.
Seniors were shocked.
Wow.
People didn't know.
Wow.
So we have to establish law school under this law as a creature of statutes.
Wow.
So imagine that some president came and said law school was no longer interested in law school, so you should shut down. Would have shut down.
Yeah. Wow.
Yes, just like that. Or some head of state in them, they would have shut down law school.
Yeah.
Because it was by government executive decision. And that executive decision now varied. We created the General Legal Council to regulate legal education, but we didn't create the training school.
Okay.
Of where lawyers will be trained under the law. So it is this legislation that has now established the Ghana School of Law with specific functions under Section 78. So the Ghana School of Law itself will also have to be accredited. So as it is, they have no accreditation.
Okay.
Okay. So all the things happening, they are doing it as a promoter. They are at the promotional stage now.
Wow.
They have to receive provisional license before they can initiate anything.
Wow.
You know. And that's what we have done. So
this one, anyone who can sing a gospel song will say Ebenezer.
yes.
This is how far the Lord has brought us. Listeners, thank you very much. This has been a conversation with Honourable Rockson-Nelson Dafeamekpor. He's a member of parliament for Dayi constituency. He also happens to be the majority chief whip. But guess what? He is the president of the Ghana Law Society. And from this conversation, I'm sure all your doubts are cleared about legal education reformation in Ghana. Thank you very much for your time.